Welcome aboard, folks. I'm Steven Malkowich, your captain on this adventure called Ship of Fools. I'm a fool. Lucky for you, I'm not sailing solo. Join me and a boatload of people, all just trying to make sense of this crazy world. It's a fabulous mess, and you're invited. In this episode, we have a candid conversation with Adam Pankratz about one of the most consequential legal decisions facing property owners in British Columbia. Okay, I'd like to welcome Adam Pankratz to our Ship of Fools, where wit meets wisdom podcast here. And thank you so much, Adam, for coming. I appreciate you coming out.
My pleasure.
And Adam, before we get into the meat of the discussion, I would like you to just tell us a little bit about yourself and your background and where you come from, and then we're going to get into the land ruling thing and the everything else.
Sure. Well, I mean, I guess it depends where you want me to start, but I'm a local guy. I've born and raised in Burnaby. Went to Burnaby Central High School. I did my first degree at Simon Fraser University, and then studied languages in Europe for a while. Worked in a number of different industries. Wine industry, did sales for a while, worked in like public relations and media during the Olympics a little bit, and then went and did my MBA at the Sauder School of Business, where I now teach. Following that, I worked in commercial banking, and then 2015, I ran as a candidate with the Federal Liberal Party in the riding of Burnaby South. And following that, via basically my campaign manager, got involved in the resources industry in the junior mining exploration, and I've been involved in that for about 10 years now, and then obviously started teaching at Sauder following my time at Coast Capital Savings as a commercial banker. Started in 2016, I think it was now, so almost 10 years teaching at Sauder School of Business in the strategy and business economics division there.
Okay, we can segue now into. You came to my attention. I was reading an article in the National Post, which you penned, and it was I think just after the ruling came down on the Cowichan land ruling that came down, and you put some you put it into perspective in that I was reading it and going, I want to know more. And hence I reached out and I said, listen, and then this has just it has become more of an issue because the implications of it they're immense. They're immense. So let's start, Adam, with a little bit of background here on I did not know this and I should have known it. But I think British Columbia and is it New Brunswick or Nova Scotia are the two provinces that don't have treaties signed. Am I wrong when I say that?
I don't want to confirm for New Brunswick because I've never followed that closely. Certainly, it's true of British Columbia.
British Columbia. Yeah. So we have. Okay. So this ruling should not this has been mulling about in the background for quite a while here, right?
Well, the issue of Aboriginal title certainly has. Whether or not we can discuss the ruling maybe more specifically, but yes, the issue of Aboriginal title and the issue of treaties with the over 200 nations in British Columbia has been an issue that has been ongoing since British Columbia opened the treaty process in 1993.
Okay. So explain this massive ruling that was it was in the courts for, Jesus, how long?
10 years.
10 years. It was in the courts. And then all of a sudden, bang, they come out with a ruling. And let's explain, let's get into this, the ruling, what it says and what it doesn't say.
Yeah, so the issue at hand was a parcel of, the judge declared Aboriginal title over 800 acres of land in East Richmond. The case went back and forth between was actually about an area of 1,800 acres, which the judge did not, the judge said that, well, I find Aboriginal title over the 800 and not the 1,000. But that area was an area claimed by the Cowichan, who had a summer fishing village there, and were claiming that area. And the judge found that they did have Aboriginal title to that 800 acres. The Cowichan, I think it should be noted, he didn't ask for the judge to rule or include private land in the declaration, but the judge did, and went sort of beyond maybe what was being asked, and said that that the private land in question, that Aboriginal title was a senior right to fee simple title, and that a precedent setting from her ruling, so that it wouldn't just apply to the area that she ruled on, those 800 acres, was that she said that a precedent of this ruling was that sections 23 and 25 of the Land Title Act do not apply. And what that means, those sections of the Land Title Act are essentially the parts of the Land Title Act which give you private and exclusive title to the land, the indefeasibility of that land. So that's the seriousness of the issue, because in the immediacy of this ruling, you have people who own property in that area who now, to what degree do they own it? We don't really know for sure, but it certainly seems that it's less than what they had before. And there's already been the residents themselves, as well as other people who followed up and asked around to other larger institutions. No institutions have confirmed this yet, I hasten to add, but that coming out of the initial public hearing on the matter, one gentleman said that his mortgage lender had told him that he would not renew his mortgage because there was uncertainty around the title on his property, and it seems that more institutions are saying, or are quietly sort of moving in that direction. So that's obviously a real concern for the residents who are in that 800 acres. But because the judge said that this is a precedent-setting ruling for sections 23 and 25 of the Land Title Act, what that means is that anywhere Aboriginal title is found to exist in the province of British Columbia, anywhere that there is private property within that area would therefore be subject to the same, I guess, diminution of the indefeasibility of their land title, and their private property rights would be thrown into question.
Which is almost the entire province of British Columbia, if at the maximum.
So this is another issue that gets to another ruling I think we probably need to talk about. But yes, there is over 100% of British Columbia is subject to land claims of one type or another. Whether Aboriginal title would be found to all of that is an open question, because generally, or in the past, like if you look at the Chilcotin ruling, Aboriginal title was found to, I think it was 2.5% of their claimed land, because Aboriginal title, in how it was initially conceived or how it had been dealt with previously, it was about occupation, not just exclusivity. So, however, also this year, there was the Haida decision, right, which the government of British Columbia went into negotiation with the Haida, and the Haida got 100% of the Haida Gwaii archipelago. So that is a very concerning development, and more concerning because the British Columbia government, or David Eby, has said that that agreement is the template for future agreements going forward. And so while the government insisted that, well, no private property is not going to be affected in the Haida judgment, that clearly is, or that seems very unlikely to be the case, because following the Cowichan ruling, if Aboriginal title is declared and sections 23 and 25 of the Land Title Act don't apply to private property, well, Aboriginal title has been declared to all of Haida Gwaii. Ergo, any private property in Haida Gwaii is no longer indefeasibly owned by those private property owners, and essentially exist kind of at the pleasure of the Haida.
Has there been the Haida Gwaii? Has there been any appeals made by private property owners up there?
Not yet. That may come. I think this is all still quite new, and certainly with regards to the Haida decision, the Haida negotiation. I'm trying to get the dates exactly right here, but the Cowichan ruling, I believe, came out like someone was asleep at the switch, because the Cowichan ruling that came out, no one in the government seemed to notice that what the judge ruled in Cowichan would suddenly apply to this agreement that they'd made to the Haida, where they insisted up and down that private property was not on the table and that no private property rights would be affected. Now, that was a dubious argument probably to begin with, because there are lots of ways you can affect private property rights without, turning it over in an agreement. But the fact now that the judge in Cowichan has ruled that Section 23 and 25 don't apply where Aboriginal title is found, that is the law of the land as it stands today. So as it stands today, the private property owners on Haida Gwaii do not have indefeasible title to their land. Exactly what they have is unclear, but it's certainly less than what they had before.
So what struck me as when the Cowichan ruling came down, I will be the first to say I was shocked that the government took as long as the provincial government. You're correct when you say, to me, it looked like the provincial government was sleeping when that ruling came down, because I do remember Eby speaking and vacillating as to what he was going to do. And I would have thought at that time that the premier of this province would know exactly and have a plan ready either way, what was going to happen or not going to happen. And that shocked me that it took as long. And because this case was going on for a very long time, and you had to know what the implications of it were. Either you didn't care, or maybe that's what you wanted. I don't know. I don't know.
Yeah, I don't know that we can say for sure. I think perhaps if we're trying to give the benefit of the doubt, where I don't know exactly what the government had in mind, whether they deserve it or not is a different question, but that the Cowichan had not asked for the private property. So the fact that the judge made that decision and kind of went beyond what the case was really about, in some senses, and sort of went outside of that to add in that, well, the Land Title Act here it does not apply. That may have surprised the government. I don't know that for sure, but that's possible that surprised them. And to try to be fair, they did appeal it quite quickly, right? Because normally you have sort of 30 days to appeal and go through the ruling, and they appealed it. I can't remember if it was on the weekend or was in a couple of days. It was very quick. It was much faster than they normally would have. I don't know if that's because they actually found to disagree with it, or more because they recognized that they had a political tornado heading their way, as people began to realize that, well, my private property is in question, and if there's one thing that people are going to wake up and take serious issue with the government for, it's if they wake up one day to find out that their private property that they thought was theirs may not be. And that obviously comes with massive political implications.
So the other thing too, and I'll ask you this question, is that the ruling or the appeal, did the provincial government, and this is, I'll say it's hearsay, but there's a little bit of written material on it. Did they appeal it properly? Is there fault in the way that they appealed it? Because there's a lot of crap floating around about that.
Well, I don't know if we know. I don't know if we know yet. I mean, they've appealed the ruling. Whether they argued the case correctly, some people have said they could have argued it perhaps differently and argued for extinguishment The judge noted that they didn't do that, extinguishment of Aboriginal title. Whether or not that was the correct argument to make, I'd more leave to lawyers to decide, although I think there's a reason to think that that is an argument the government maybe left, sort of pulled its punches on that and could have argued more forcefully for that. But in terms of the appeal, it hasn't really gone forward. What's interesting or it hasn't happened yet, so we don't know what arguments will be made. What is interesting though now is that Montrose Properties, who's the largest landowner in that area, private landowner in that area, they have asked for the case not even to be appealed, just to reopen the case because they were not aware that this was happening, and they feel that their arguments or what they would have argued, and that would be quite an extraordinary thing if they just reopened the case. That may happen as well.
Is that plausible? Is that actually?
I don't know if it's plausible. It's possible. But that's what they're asking for to happen right now.
And the judge granted an 18-month stay, though, too, right?
So the judge granted. So again, yes, on parts of it. So the judge granted an 18-month sort of time for the private lands in that area that are owned by the city of Richmond and the federal government. So owned that, but not
for private.
No. So for the private, like you or I, if we those, it's for the provincial government immediately to go and start to figure out what they do with those lands, with the city of Richmond lands and the federal lands. In the case, the Port of Vancouver, they have the 18 months to figure out what they're going to do. But for the other private landowners, as it stands today, the provincial governments, would have the responsibility immediately to go and start dealing with that.
Okay, there's a lot of I don't want to say misinformation, but an understanding. There's not an understanding of what the ramifications of this are, and the kettle of like the I say kettle of fish, or the opening up this container here. Why should everybody in British Columbia be concerned about this?
Well, I would, again, you're right that you've opened a can of worms, and many people are not sure how far the ramifications go. But okay, obviously on the one issue you have just landowners that and the Land Title Act, which underscores so much of what we take for granted in society, right? If I own a piece of property, I own it. That's a basis of our society.
That's our society.
Everything.
It is.
In the BC context specifically, you have to kind of, I think, link the two together, the Cowichan and the Haida decision. And here I wouldn't, speculate myself. I would just use the government's own language. And what the government has said, what David Eby said during the Haida when they were finalizing the agreement, was that the Haida agreement was the template.
Yes.
That was his way. He said it was the template for future agreements with nations in the province of British Columbia. So the question there is, well, how many other Haida-like agreements are currently being negotiated that we don't know about? Because if there's one thing that has characterized this process under the Eby government and is very concerning, is the secrecy and the lack of transparency. And we don't know how many more of these agreements are out there. So if the Haida agreement, which granted 100% of the Haida Gwaii archipelago to the Haida, and did not subject it to the more rigorous Aboriginal title tests of occupancy, like in the Chilcotin case, well, what does that mean about future land agreements over large swathes of the province? And when you see, I don't know for a fact that these things are going to happen. But when you look at, you start to piece together little pieces of information that the government, a year ago, they put a moratorium on all mineral and exploration claims on the northern third of the province, which is an area of about 16 million hectares. Well, is that because there's a land deal that is up there in northern British Columbia that we've not been told about, and they're preparing to make a Haida-like agreement with one of the nations up there? I don't know, but that's just the problem is we don't know that. And as a result, if you're a property owner in northern British Columbia, should you be concerned, or anywhere else in the province for this matter, if the Haida template is going to happen and you put that together with what the judge ruled on Cowichan and you start putting all these pieces together, then there starts to be real uncertainty about, the scale of how big this could be and how many pieces of property could be affected, and how this could affect, the economy, the social cohesion of British Columbia. I think there's a lot of things up in the air at that point. So I don't think you can understate the importance of it when you combine the way the government has acted thus far and the implications of the judge's ruling in the Cowichan case.
So have you personally, I know you've established, you have an acronym as PLUS, the Public Land Use Society. How long has that organization existed for?
Not quite a year.
Okay, so it's brand new.
It is. It's, our timing has, I guess, been quite good on that. But initially it started, we were concerned, with our background in the mining industry, we were concerned about changes that were being made, as far as we were concerned, in secret and without proper consultation of the industry and stakeholders, for the Mineral Tenure Act.
Okay.
And that's where we noticed these, moratoriums on claims and how people were able to prospect and stake, and had real concerns about why that would be an issue for the mining industry. I don't need to bore you with the details in case you want to hear them, but they were real concerns, and a lot of it came down to but at the base of it was, well, what you were allowed to do on Crown land, just as a citizen of British Columbia, to go out and explore, to go bird watch, to go hunt, to go do anything. And a lot of where we felt the government was moving with this was that they were limiting the ability of what British Columbians would be allowed to do on Crown land, which is land for all British Columbians.
Includes parks.
Yeah, absolutely. Yeah. And the same, along with that, we'd seen I guess it'd be the Lillooet Nation shutting down Joffrey Lakes, not allowing people into public parks. So we said, no, we want to try to get this message going that public Crown land is for all British Columbians, and we want to make sure that access is maintained for it. That was the genesis of why we started doing that. Obviously now, since the Cowichan ruling, this issue has, I don't want to say caught the public imagination because it's real, but really, really come to the fore and sort of breached the smaller political circles that pay attention to this on a more regular basis. And so now we have expanded our mandate a little bit, I guess, to make sure that we're communicating not only what's going on with private lands, but just helping people understand as well what's happening with private lands and what these judgments mean and how they could affect British Columbians.
So the thing is that there's a lot of, and one of the reasons I wanted, obviously the big reason I wanted to have a conversation with you was that there's a lot of misinformation traveling around, and I am in the newspaper business, and our job, and contrary to what everybody will say, I don't consider us to be like we're small town. Like but we try to get the information that we're putting out there correct, and it's been difficult trying to get correct information because I guess it's still in flux. It's still, but if how do I put this without every British Columbian that should be concerned, because it is the fundamental basis of what our society, what we're based on here is that you own a piece of property, you own dirt, you own the land. If we just all become, we've got to, we build a building and we're just leasing the land of the entire province. That I know that I'm being facetious somewhat when I say that, but not really. I'm going, because if I take this as far as, that's in essence where my head goes, is that, okay, well, are we subjugating ourselves to being in court for the next however many years fighting this out? Like,
Well, maybe. And you raise a good point there, right? I mean, there's multiple ways to approach this, but even for, say, the landowners in Richmond, even if this is appealed, it wouldn't end at the BC Court of Appeal. It would
go to Supreme Court of Canada.
Supreme Court of Canada. Yeah, for sure. Well, that could take 10 years, right? That wouldn't be, that wouldn't be impossible. It would take that long. In the meantime, right? Well, that could mean it's not fanciful to think that could mean financial ruin for those people, because who knows what
markets,
happens.
that's right. Markets don't like uncertainty. Banks don't like uncertainty. So, you want a mortgage, you want whatever they don't like uncertainty. They like certainty. Now, we never have 100% certainty, but they like to mitigate the uncertainty. So all this does is it ramps up the uncertainty, and like majorly.
Absolutely. And you're right. We never have 100% certainty, but I would say, just coming from financial background, like what do banks always ask lenders to tie their loans to?
Yeah.
It's their house or their piece of property.
That's right.
Why? Because, well, if everything goes wrong,
That's right.
the land is,
That's right.
that's the last kind of reserve,
right.
right? So yeah, there's that. And the banks are not going to come out and say, they're gonna keep their cards close to their chest and wait and see what happens. They're not probably going to make pronouncements on it until they absolutely have to. But the other part of it, like aside from the massive uncertainty, is if this starts happening to more people, or it happens in more cases, and the public of British Columbia or Canada, because it would be a Canadian precedent, although the situation is different in other provinces. If the public starts to suspect that, sort of what reconciliation means is that my private property is up for grabs, any support for that is going to unravel in a huge hurry. And I think it, in some senses, already has. I don't think it's unraveled completely, but I think if you look at the way people are talking about this in the media and the articles that are being published and written compared to even 3 to 6 months ago, there's definitely been a shift in the public mood, right? Mm-hmm. And there are things being said or written in newspapers and interviews that are being published that would not have seen the light of day, I don't think, 6 months ago. Mm-hmm. And that's reflective, I think, of the public mood that has really shifted on this. And that's not good, right? Mm-hmm. I mean, you don't want to get into an us versus them on this. And I think that's important to say as well. Like, this isn't the fault of the Aboriginals mm-hmm. Or the First Nations. This is the government's fault, that they have not done a good job of protecting private property rights for British Columbians. And so the First Nations have kind of been given the choice, well, do you want this deal or do you want a better deal? And they've mm-hmm. said, well, we'll take the better deal. Mm-hmm. Anyone would do that, right? The government that deal should never have been on the table in a lot of ways, right? The government should have done a more solid or a more fundamental job of protecting the rights of British Columbians. And that's, I think, where the frustration or the anger maybe of British Columbians should be squarely directed, is at the government.
Well, the unfortunate thing is that what this has done is it's flourished. It has flourished contempt. And I mean that, and I'll call it, if it's the elephant in the room, it's flourished contempt for First Nations. It has. It really, it has. I'll call it out, because there, and the government allowed. You're right in saying this. The government allowed this to happen. They could have handled it a lot differently. Now, what was there was our federal government and our provincial government. There was a ruling at the United Nations level. I can't remember what.
Oh, the UNDRIP,
Yeah,
United
yeah, yeah.
Nations Declarations on the Rights of Indigenous People. Yeah, so that's a different issue. Okay, so
Let's talk about that.
So the United Nations Declaration on the Rights of Indigenous People, known as UNDRIP, we call it. That is I think you can best describe it as like a human rights document, and intended or written as an aspirational document for Indigenous peoples where there were real or are real and ongoing abuses of those Indigenous people, right? So it looks at the world, the whole world, and basically says, okay, Indigenous people ought to, or like, these are the human rights of Indigenous people, right? It was never really intended, as law, and it certainly was never intended to, I think it's fair to say, be applied to a country like Canada, where we have constitutionally guaranteed protections for Indigenous people, and we are not, actively abusing them, and we are doing many different things and have been establishing precedent on how to balance the rights and wrongs of what's happened to Aboriginal people in the past, balance their rights with the rights of non-Indigenous Canadians, right, or non-First Nations Canadians, and that's what we've been working through with Section 35 of the Canadian Constitution. So okay, so that's the background on that. So, but that document, what British Columbia did was they instituted DRIPA, which is the Declaration of the Rights of Indigenous Peoples Act, which says that the laws of British Columbia must be brought into alignment with UNDRIP. Okay, so what the government currently is doing is they are aligning the laws of British Columbia with UNDRIP. And the government of Canada, I believe, has done that too, right? So that is potentially quite concerning, because that is there are a number of provisions in UNDRIP, such as if an Indigenous group claims a certain area, they own that area, where that's not the test that we have for Aboriginal title. It's occupancy, and there's a rigid test that we go through. And like I mentioned earlier, often that results in Aboriginal title to a much, much smaller area than the area claimed. There's also provisions in it, such as that the governments must consult for the promulgation of laws. The Supreme Court of Canada has been very clear that the governments don't need to consult First Nations to write legislation. That's what's going on in British Columbia right now. I mean, I think it's being done behind closed doors, but this government is not writing legislation without the consultation, or in some cases perhaps the agreement, of First Nations. And then in UNDRIP, there's also the FPIC, the free, prior, and informed consent notion, which basically says that you can't, on an area that's claimed by an Indigenous group, anything that happens on that land, they must have free, prior, and informed consent. In Canada, we have the duty to consult and accommodate, right, which was determined under the HIDA in 2004, the case. So, the consent notion there, like, does that mean that on non-Aboriginal title, simply claimed lands, that the government would need the consent of First Nations to do anything, right? To permit a mine, to build a road, anything. It could be. And so that's, at the very least, it's muddying those waters. And at worst, it's setting precedent where even under lands which are not Aboriginal title, merely claimed. Essentially, the First Nations have, somewhat of a veto over what happens on that area, which again is something that the Supreme Court has said they do not have, and there's infringement. There's infringement provisions, reasonable infringement provisions, where under certain circumstances, even on Aboriginal title land, the government could infringe on those rights if it were deemed to be significantly or to a significant degree in the public interest. So, UNDRIP is certainly muddying the Canadian waters. We had a process. We had a reconciliation framework, which is Section 35 of the Constitution, and UNDRIP is which Section 35 balanced the rights of Indigenous First Nations Canadians and non-First Nations Canadians. And UNDRIP has, I'd say, thrown that into question and is causing, a lot of decisions to be made that don't balance those interests and should be concerning.
So, what is the thing? The thing is that is anyone pushing the provincial government to be more transparent with what they're doing? Like, is Plus doing that, or is who's doing that? Who's advocating? I don't mean to be trite when I say this. Who's advocating for landowners in British Columbia for the government to be more transparent? Because when we did talk on the phone, and I was just babbling a little bit, and we were talking about the Richmond situation. But then I brought up the interior of BC. Okay, there's people that own a lot of property in the interior of British Columbia. There's farms. There's all kinds of things. What are the implications there? My mind can go, I can go squirrely thinking about the implications about this. But what organization is taking the lead in holding the government's feet to the fire in regards to transparency with what they're doing? Because we don't know.
Yeah, I mean, certainly the Public Land Use Society, Plus, that's what we're trying to do and are working towards that end. I think since the Cowichan case, not all groups necessarily have fully come forward, but there was a letter sent to the Premier from the Cattlemen's Association a few weeks ago, which they now are on board with that. And I think the Cowichan, again, this is where the Cowichan case, even though it's not always about public lands, or it's because it touched private lands, people have paid a lot more attention. And I think more and more groups now are going to start advocating on this. It's taken a little while for them to decide how and what and understand the implications since the ruling came down in August. But I would not be surprised if you see more and more business organizations or industry organizations or even outdoor activity all types of organizations who require access to public land or want certainty on private land rights to begin advocating much more strongly on this in all of their various different ways in 2026. I think that is something that probably will characterize this issue in the year to come. Would be my guess.
Did it, because it is striking to me though that this and you alluded to it at the beginning when we were talking, that the government was they were kind of sort of caught flat-footed, like they if you, because I can take it to the nth degree too here. We're taping this out in White Rock. There's a Semiahmoo First Nation is right on the water here.
Mm-hmm.
I'm damn sure that they can lay claim to everything here. Okay. Now I'm pretty sure of that. Is that like, is this ruling going to begin a cavalcade of cases thrown
well, this is part of the issue. We don't know. It came to light a few weeks ago, I wrote a piece on this as well, that the Kamloops First Nation, they've claimed all of Kamloops, right?
Yeah.
And Sun Peaks. And this is where you get to that issue of the scale of this, right? Because if you said, okay, well, this is 800 acres in Richmond, the land there is worth about $2 billion. And if there were these isolated instances where there were small pieces of private property, even in the worst case scenario where indeed those people were found that and things for them would go very badly, but that you'd say, okay, well, the government could figure out a way financially to deal with that, right? Like $2 billion in Richmond, more billion somewhere else, but that would be somewhat manageable. But when you start saying that, well, it's all of the city of Kamloops now is claimed. Well, the value of land in that area is like $43 billion. And then the value of private land in British Columbia is $2.8 trillion. Well, the government can't financially deal with that, right? So the scale of this is an issue that, again, I don't think we've fully come to terms with, or we're still grappling with Richmond at this point. But yeah, this is a serious concern. And again, not only that, but we found out about Kamloops, but is that true about Kelowna?
Yeah.
Is that maybe?
Yeah.
We don't know.
Penticton?
Maybe. Again, we don't know. Because these agreements, and I mentioned it already earlier, but a lot of these discussions and negotiations are being done in total secrecy, and the government is not forthcoming at all in what they are doing. And so we could wake up, we're on a Sunday today, we could wake up on Monday and find out that, Asuyas is up for grabs. I don't know. So that is probably, or not probably, is certainly one of the largest issues with this, is that the government is not transparent about what they're doing. And British Columbians are not part of the process, right? And Richmond landowners were never notified, right, that this was going on until they found out, oh, you might not own your private property. And I would say that is also the case with the Haida decision, or the Haida agreement, where the government didn't manage to put two and two together and realize that, oh, the Cowichan decision has said this. Well, now everything we were saying about private property in Haida Gwaii is out the door. And, private property owners in Haida Gwaii wake up to find out that this ruling in Richmond now means that section of the land title doesn't apply and you don't have indefeasible right to your land.
And people don't, the thing is that the unfortunate thing is that nobody cares until it affects them. Like, it could potentially affect them. Like, I mean that's the way we are as human beings. Like, we don't care until, I personally can't believe that we still have the Massey Tunnel, but that affects me every single goddamn day because there should be a bridge there, but until it affects you, or it could potentially affect you, and you say, you know what, I can lose my house.
Well, and I think also, not only it's private property in the Cowichan case, but it's private property in the Lower Mainland, and I think, which obviously where the majority of the population of the province is. And I think, again, this is a bit of speculation as to how people are feeling in the Lower Mainland, but I think with a lot of like Aboriginal land title issues, I have this sense, right, that people in Vancouver are like, oh, that's a rural issue, or that's Crown land a long ways away from here. So that's never going to happen in downtown Vancouver, right? And then all of a sudden, boom, it happens in Richmond. Well, now everybody's paying attention, and also the government is reacting because that's where the most votes are.
Yeah.
That's the Lower Mainland. If the people in the Lower Mainland are all of a sudden saying, "Oh, this isn't just like happening in Prince Rupert or Prince George."
Well, in Haida Gwaii was like, okay, well, that's okay, but that's still but it's not. The other component to this, though, is that there's, in effect, there's mining operations, there's farms, there's all kinds of things, businesses, there's all kinds of economic activity on these lands.
Mm.
There is.
Absolutely.
And like who like I'm perplexed. I really am perplexed.
No, I mean, the private land issue is what's got people's attention, but the crown land issue, I mean, in terms of our ability to succeed economically as a province and as a country, I would argue, that's 95% of the province is crown land. If you're going to go mining, if you're going to build a pipeline, if you're going to do forestry, if BC Hydro is going to do anything,
Dam,
more like anything, right? Anything you can possibly imagine. These and just access to the land. All businesses rely on this, right? For whether it's for building infrastructure, anything. If we don't, as British Columbia, protect that and have certainty around what the government and here I might, that's a serious problem. And here I might also, get a little bit more philosophical and nerdy for a second is the crown land issue, right? And if you start to think about what the larger implications are in terms of like, is consent required? Look at we'll go back to Haida Gwaii, right? So the Haida Gwaii now is going to be governed by the Haida. Okay. Well, there's a huge democratic issue there at play, which we haven't discussed at all. In like, if I don't like what my local municipal government or the provincial government is doing, I can, as a citizen, go vote in an election and try to change that, right? And okay, I may not get the result I want.
but that's democracy.
That's democracy. That's how it works. And obviously then more people disagree with me and fine. Okay, that's the system I live in. On Haida Gwaii, though, you can't vote in the Haida election unless you are Haida. Okay? And that's true about probably I think all First Nations. You cannot vote in those elections unless you are First Nation. So now, though, if decision-making power is being devolved from the government to First Nations, which affect non-First Nations, and those, non-First Nation British Columbians are being affected by decisions that affect their ability to economic prosperity, or their decisions in terms of what can happen on their own private land or anything, right? They can't go and say, well, I want to change that government because they don't have a right to vote in the First Nations election. Well, that's a serious democratic issue.
That's an issue.
That's a serious issue, right? And that's, where, we understand the government wanting to give maybe more decision-making power to the First Nations. But if that decision-making power is then affecting others who have then no say and no recourse, that becomes a problem, right? So, and again, there's lots of ways you can, like on Haida Gwaii, even when the government was saying private property was not affected, there's lots of ways you can affect values of private property that aren't actually physically seizing it, right?
Mhm.
Property taxes or what you're allowed to build and all kinds of things. And non-Haida would have no ability to change that they didn't like, right? So that's a separate issue in a sense, but it's a serious one. It's like there's a potentially huge, I guess, democratic deficit in some of these agreements, which greatly affect the people around them, right?
Mhm.
And that's a serious problem.
So the once again back to and I'm gonna put it on the provincial government. I have no problem putting it on our provincial government.
Yeah, and so
this issue.
absolutely.
This is they've allowed it.
Yeah.
They're not being transparent about what's going on. There is no the recourse for the average for a citizen. What's your okay? Well, you can phone your MLA. And what's the federal government doing? Are they just watching this and going, oh, okay, well, what part does the federal government play in this? Because when you start talking about crown lands, there's there's federal lands, okay? Like, does this judgment affect federal lands too? Like, I understand, and I can stand to be corrected on this. All the coast, that's federal land, right?
It's federal jurisdiction.
Federal jurisdiction, federal land.
Yeah.
But some of this land that in that Cowichan ruling is coastland too, right?
Well, there's federal land, the Port of Vancouver,
Yeah.
on the Fraser River. So there's federal land owned by Canada in that ruling, along with private land owned by the city of Richmond, and then there's just the fee simple.
Yeah.
private property owners.
So the federal government has to this decision or this ruling that affects the federal government, and they're and are they doing? Is the federal government just going, okay, well, we're just going to sit back and wait and watch this thing play? Like, I'm asking a question in a roundabout way.
I don't think the federal government. I mean, the province of British Columbia has appealed this, as have the Musqueam and as have the Cowichan. Because the Cowichan say, well, we want
because it affects Musqueam.
They want and so all three, like the province of British Columbia, the city of Richmond, and the Musqueam have appealed against this ruling. The Cowichan have appealed it because they want not 800 acres, they want the full 1,800, right? They've said we want so the larger piece of land. The federal government, to my knowledge, has not was not involved, or they have not appealed it, not pronounced on it. So the province is negotiating with the First Nation at this point. So it's not. So the federal government haven't really made any decision. Although, they once agreements are reached, right? I don't want to say anything that's not true here, but they do need to sign off, like on treaties, I believe, if I'm not mistaken.
Okay.
Once they're agreed to. But.
Okay. Now I'm going to ask a really. I could say it's a stupid question, but. We're talking, okay, you've got the court case, the Cowichan, it was against the Musqueam. Like the Musqueam are involved in that. That was the lands that the Musqueam had claimed, right? That they were given to Musqueam, correct? That some of that land there is Musqueam Nation land. Of those 800 acres or whatever. No,
not to my knowledge.
Okay. But I could be wrong on that. But who's funding all of these? The cases? The Canadian taxpayer or the BC the taxpayer?
Yeah, the government.
Right?
The government funds it. Yeah,
the government's funding it.
Yeah.
So we're funding all of this.
Yes.
Right. That's a lot of money.
It is.
We're funding First Nations to sue each other. Then we're funding the provincial government to sue or to take to court or appealing a ruling. We're being inundated with legal bills.
What I would say is that for many now, there certainly are nations who have the financial means to bring these cases themselves and fund them themselves and probably do in many instances, or can now. I guess the logic behind that would have been that, it would, if you refuse to, you've created a situation where nations can't advocate. That would be no different than, poor Canadians or disadvantaged Canadians not being able to access justice. And so the government decided to do that. I don't know exactly how that came to you. That would be my assumption that the government felt it had a responsibility to help those First Nations make their case.
And I'm not disparaging that. I'm making a point here. And I didn't realize until this happened either, Adam, that BC didn't have any treaties. I didn't know that. I coming from Manitoba, coming from the prairies,
they're all treated.
Yeah. And my father worked for the Department of Indian Affairs for 27 years.
Oh, okay.
Yeah, in the federal government. Okay, so until he left in the 70s. So I have my, I have a background in like the prairies are the prairies. It's different here, very different. But where do you see this? Let's sort of talk and if 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 people are listening and or watching, what would you say? What do you suggest, or what would be your recommendation or direction that that concerned people that are concerned legitimately get legitimate information about this? Because there's a lot of information, there's a lot of content floating around. I read, but a lot of people don't, and a lot of people don't care until it directly affects them. They get a knock on the door. There's always situations that have arisen in my community here where I've sat back. Now, there's one. I don't want to change the subject here, but there's a big one here going on in this vicinity here that's it'll be on the news. Where would someone? What is a good source of information to tell? Like and I'm not just saying, like, I'm not talking like dragnet, just the facts. A good rounded out version of what's transpiring here.
Yeah, well, I would say two gentlemen who have been spoken publicly about this, and are the experts in the field, and certainly have helped me understand it, and plus understand it, is Tom Isaacs, who was on the Global News. He did an interview with Jordan Armstrong, where he spoke at length about this, and then Jeffrey Moyse. So Jeff was also, he advised, I think, 6 governments, BC governments over years about this and the treaty process and everything. And he's also spoken on multiple available podcasts if you Google him, to explain the ruling, also the implications of DRIPA and all of these different things. So Tom and Jeff are the two experts we're very fortunate to have in British Columbia, and they've been great in terms of trying to educate the public about just what's going on and what the situation is and what the rulings actually mean and what the potential implications are.
Mm-hmm. Now, you in wrapping things up here, and let's talk. If people wanted to get involved with PLUS, the Public Land Use Society, how would they go? Are you? I don't want to put words in your mouth. Is the public land use? I understand why you were created at the beginning, but this kind of fell. This situation arose. Are you actually is PLUS advocating for the private landowner as well?
We're trying to. I think the answer at this point is yes.
Okay.
We sort of expanded our scope because of what's happened. So yeah, we're trying to make sure that the government is transparent in what's going on and that the public is aware. And really, I think the value I hope that we bring as PLUS is that there isn't. You asked earlier, is there sort of one place that's advocating? That's been an issue in the past, and another area we've come to realize that the Public Land Use Society PLUS has a role to play in terms of bringing together all different types of groups who require access to the land or have questions about land use that may not get along like outside of that, but at the base of it, they need to understand the land issues, and they need certainty in terms of what they're allowed to do on both private and public land. And that's, I think, we're at a good aggregator of bringing that message together and saying, okay, there's all these groups that have economic or leisure or other interests in the land, and they need to speak with one voice, and that's what PLUS is trying to do. So anybody who's interested certainly can go.
What's your URL?
Yeah, it's publiclanduse.ca.
Okay.
And anyone can find us there.
Now, lastly, I want you lecture at UBC at the business school.
Yep.
What's the climate like with regards to this issue at the student level?
I mean, that's tough to judge because I've only experienced it in one course where we talk about this with students. I think they're surprised to learn about some of the things that are going on. Um, I think it's an issue probably most of them haven't, like,
Really thought about.
many students don't.
Yeah.
Who thinks about land use?
Well,
not
yeah,
most people haven't probably until recently.
Yeah.
And I think that's no different with the students. Certainly ones that, if they're more specialized in real estate, they have more concerns and they see them immediately. But all of them, I mean, what every business student knows is, like what you said, is that business hates uncertainty.
Yeah.
And they certainly can see that if land, your private land title is in question, that has enormous economic ramifications for the person involved and for the province and the country as a whole. So once they see that that's going on, right, their immediate question is, well, like, where would the money come from to fix that, and how would we pay for it? And so they go down the economic implications pretty quickly and see them very, very quickly. So I think that's the main reaction I've seen from students.
Lastly, the mayor of Richmond sent a letter out too. And what do you think of that the letter that he sent out to the residents of Richmond?
Well, I guess it depends what you mean. I mean, he stated something that was basically true.
It was true.
I think those residents probably should have been notified earlier. Not necessarily by him, or by Richmond, but in some way. Because again, we keep coming back to the transparency issue, is that all of these issues like, nobody knew that they were happening, and the government was not forthcoming with this. And again, that raises
That
the
letter,
question.
that letter scared the shit out of a lot of.
Of course it would have. If I got a letter like that, I'd go ballistic. And anybody rightly would. You get a letter. Oh, I don't own
my
house. Yeah. Okay. And again, this is the issue. Well, how many more agreements that we don't know about does that apply to? And I think that's the real concern. So I think that the letter was a legitimate thing to send out and inform them, because it was true. I mean, it was true. And but it should have been. People should have been aware far earlier.
Yeah.
Is all I would say on that.
Okay. Well, on saying that, I know we've just touched the surface of things here. We've been talking for an hour now, but I'd like to thank you, Adam, for coming and sharing, putting some light on this. And I would encourage anyone to. You've written a number of articles too, which are informative, and we'll put that in the show notes. We'll also mention Plus and that, and I think people should. This is an issue that people should give a shit about. They should care about, and it's not just a Lower Mainland thing.
No,
this is a BC thing.
Yeah,
and I don't believe that that a lot of people, until this happened, were not aware. And what we have to do is we have to push the provincial government for more transparency, because that's the last thing I want in my mailbox showing up. That, oh, by the way, you don't own your land, and that's a fundamental principle of what our society is based on. I shouldn't laugh because it's not funny.
No, you're right. And I think that people who are concerned, they should go ask. They should go ask the government, like, what is actually going on. Tell us. And demand that transparency be there, and the more transparency that's there, the better the process will be.
Okay. Well, on that note, thank you, Adam. I really appreciate you coming out today.
My pleasure.
Thank you so much.
Thank you.
You may be asking yourself, what's any of this got to do with me? Absolutely nothing. Until next time.